Hi, my name is Lee Chi Ho. So I'm going to describe this slide. So for the essential element of the contract, they have 10. So divided into two parts. So in the law and contract, part 1 consists of offer, acceptance, intention to create, legal and capacity and consideration. These 5 elements will be described by another group. So our video will describe the law and contract part 2, which is consists of consents, unlawful and void contracts, term of contract, discharge of contract and remedies of contract.
The objective is determine valid consent according to Contract Act 1950 as one of the essential elements of contract. What constitutes consent? Two or more persons are said to consent when they agree upon the same thing in the same sense. Void is agreement in which no rights or obligations are created. Voidable is agreement which gives the rights to the parties whether to affirm or reject the contract. The circumstances that will affect the validity of agreement is coercion, undue influence, fraud, misrepresentation, and mistake. Coercion means manipulating a person to behave in an involuntary way by threat or some other form of source. For example, putting a gun to Abu's head to compel Abu to transfer his land to Mina. The unlawful detaining or threatening to detain any properties to the prejudice of any person. For example, threat to close down his market stall and to seize his goods if he refused to enter into agreement. The effects are rescission, restitution, and compensation. The meaning of undue influence is one person taking advantage over another by the position of power, usually to persuade someone into signing a contract. Party to the contract had lost the ability to exercise his or her judgment, usually through domination and the use of position to obtain an unfair advantage in the contract. Circumstances of undue influence is real and apparent authority over the other, such as father over child, fiduciary relationship, such as lawyer and client, and mental capacity is affected by the reason of age. For example, T was the owner of one piece of land. J has a lawyer and T had used his position to influence T to transfer his land to the third party. The effects of undue influence is a party to the contract may rescind a contract on the ground that he has entered into that agreement by influence of the other party. The meaning of fraud is a deception made for personal gain or to damage others. Active concealment of fact by one having knowledge of the fact, a promise made without any intention of performing it. Though silence does not constitute a fraud, but in some cases, yes. Cases such as a position of trust to speak and disclose all relevant information. For example, Kyung sell a radio for $599 telling Amina that it is truly functional when he knows that it is actually totally broken. The meaning of misrepresentation is a false statement of the fact made by one party before or at the time of making contract. Examples: A is telling the buyer that the radio is practically new so that we buy it. It is in fact 5 years old and heavily been used. So in the above example, if the seller did not know the radio was actually old, he would only be liable for an innocent misrepresentation. Innocent misrepresentation is a representation of one of the fact is false but he believed it to be true. Negligent misrepresentation is there is a duty imposed to a party to disclose information to each other. Opinion and silence is not misrepresentation. The effects are rescission, restitution, and compensation. Mistake is void because they would not enter contract if they know the facts. The meaning of mistake is where both parties were unaware that the subject matter of the contract has already perished at the time of contract was entered into. Mistakes such as both parties and matter of fact essential to the agreement. There is unilateral mistake of fact to identity, quality, and law.
As the introduction, void is an agreement and not enforceable by law. Contract also may be void and illegality, but Contract Act 1950 it doesn't distinguish both of it, which is void and illegality. In Section 10(1) of Contract Act 1950, the contract must be made by a free consent of competent parties for a lawful consideration and with a lawful object. According to Section 24 of Contract Act 1950, the consideration of object is lawful unless the first is forbidden by law in Section 24A and B. The second is contract that are fraudulent in Section 24C. The third is injury to person or property in Section 24D. The fourth is immoral or opposed to public policy in Section 24E. And the last one is by nature. If permitted, it would defeat any law. The void but not necessarily illegal is known as the first consideration for one or more objects in Section 25. The second is agreement without consideration in Section 26. The third is agreement in restraint of marriage a person in Section 27. The fourth is agreement in restraint of trade or business in Section 28. The fifth is agreement in restraint of legal proceeding in Section 29. The last but not least, the agreement that uncertain in Section 30. Based on Section 28, an agreement exception of contract in restraint of trade is the agreement that not to carry on business of which goodwill is sold. The second is agreement between partners prior. The third is agreement during continuance of partnership. Regarding to the Section 19, exception of contract in restraint of legal proceeding is the first contract to refer dispute or refer any question. The second is contracts in respect and award of a government scholarship. For the consequence of illegality, the general rule under Contract Act 1950 that the court will not enforce an illegal contract.
Hi, my name is Lee Chi Ho. Today I'm going to describe the term of contract. There is two types of term, which is express term and implied term. Next is the express term. The express term is laid down by the parties themselves. Key issue is whether oral statement made during negotiation prior to conclusion of contract become a term of contract or remain were representation or promise. Next is the implied term. Implied terms are read into the contract by the court on the basis of the nature of the agreement and the parties' apparent intentions or on the basis of law on certain type of contract. Implied terms are not written down anyway, but are understood to exist. So next is the contractual term. So there is three types of contractual term, which is conditions, innominate term, and warranties. Conditions are the most important term of contract. Serious consequence if breached. Innocent party can treat contract as repudiated and thus is free from rendering further performance of a contract and can sue for damage. Statute may determine that certain terms are to be treated as a condition. For example, Sale of Goods Act 1979 provides that certain terms relating to the title to goods and qualities of goods are not just to be implied into consumer but the contract but also to be conditioned. So next is the warranties of lesser importance than the condition and can be breached without such serious consequence. The innocent party can sue for damage but it is not able to terminate the contract. A warranty is a term of contract which is collateral or subsidiary to the main purpose of the contract. It is therefore not so vital as to affect a discharge of the. So last is the denominator. There can be either conditions or warranties. Which of them can be serious or trivial depending on particular fact situation. If effect serious, there are conditions and vice versa. Introduction of this category of term has given more flexibility to law, but also create more potential for uncertainty. Hence, courts have subsequently been inclined to hold that certain terms will usually be conditioned to give commercial actor in a particular market certainty. So that's all for me. Thank you.
Hi, my name is Falzena and I'm going to explain to you about discharge of contract. When the contract is terminated, it is said to be discharged and the contracting parties are free from further obligations arising from it. Contract is discharged when it is terminated in one of these ways. First, by performance, second, by consent or agreement between both parties, third, by impossibility or frustrations, fourth, by breach from one party. Generally, parties to contract are bound by an obligations. Performance is the usual method for the discharge of a contract. In Section 38(1) provides they must either perform or offer to perform their respective promises unless the performance is dispensed with or excused under the law. Discharge of contract by performance. There are four types. The number one is time for performance. A promiser must be prepared to perform his obligations at the time and place at which he has undertaken to do. For example, if Ali promised to deliver goods to Mutu on the 3rd January 2012 on payment of 3,000 ringgit, thus Ali is bound to deliver the said goods to Mutu on that day and Mutu is bound to pay the 3,000 ringgit. Inside time for performance, there are effects of failure to perform at the fixed date when time is essential. In Section 56(1), when a party promised to do certain things at or before the specified time, fails to do such things, then the contract became voidable at the options of one of the party. The next one is effect of failure to perform at the fixed date when time is not essential. When there is a failure of the parties to perform the contract does not become voidable, but the promisee is entitled to compensation for any loss he suffered. The second one is place of performance. There is a place being specified for the performance of the contract. The parties must perform the contract at the place specified. If there is no place specified, the promiser is under duty to ask the promisee to specify the place of the performance of the contract. Section 50. When a promise to be performed without application by the promisee and where no place is fixed or specified for the performance, thus it is the duty of the promiser to ask promisee to appoint reasonable place for the performance of the promise. Here is the illustration for place of performance. A undertakes to deliver 1,000 gantings of rice to B on a fixed day. A must apply to B to appoint a reasonable place for the purpose of receiving it, and A must deliver it to B at that place. The third one is by whom a contract must be performed. In Section 41, if it appears from the nature of the case, intentions of the parties that the contract should be performed by the promiser himself, then such promise must be done by a promiser personally. An illustration, A promised to paint a picture for B. A must perform this promise personally. The last one is performance by third party. In Section 42, when a promisee accepts performance from a third party, he cannot enforce it anymore against the promiser. Discharge of contract by consent or agreement between both parties. Contract created by consent can be extinguished by consent either express or implied. Express consent may be given at time of contract or subsequent to that. For example, discharge at the occurrence of an event, waiver, release, novations, or rescissions. In Section 63, if the parties to a contract agree to substitute a new contract for it, or to resign or alter it, the original contract need not to be performed. Illustrations: A owes money to B under a contract. It is agreed between A and B that C will become the new debtor. The old debt between A and B is at end or discharge, and a new debt is between A and C. While in section 64, every promisee must dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it satisfactions which he thinks fit. And in illustrations, A owes B 5,000 ringgits, A pays to B 2,000 ringgits, and B accepts in satisfactions of the whole debt at the time and place at which the 5,000 were payable. The whole debt is discharged. Discharge of contract by impossibility or frustrations. There are two categories of impossibility of contract. First, when impossibility is at the time of making the contract, an agreement to do an act impossible in itself is void. Second, a contract is frustrated when there is a change in the circumstances which renders a contract legally or physically impossible of performance, not merely difficult or more enormous. In sections 57, bracket 2, a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promiser could not prevent, becomes void when the act becomes impossible or unlawful. In applying the rule, court will examine the circumstances surrounding these frustrations, including whether it is self-induced or not. A contract may be discharged in any of the following circumstances. First, destructions of the subject matter, Taylor v. Caldwell. There must be total destruction, not partial, due to Section 12 of SRA. Second, supervening event defeat the whole purpose, object of the contract, Henry v. Krell. Third, death or personal incapacity, especially in regards of personal obligations. Fourth, supervening illegality, Lee Kin v. Chan Swan Eng. Effects of frustrations automatically end the contract. Section 66 CA provides for a restitutionary remedy. Discharge of contract by breach from one party. When a promiser fails to perform his obligations or to tender performance, there is a breach of the contract. The party not in breach entitled to take appropriate actions may include repudiations, rescissions of the contract. In sections 40, when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee to a contract, unless he has signified by words or conduct his acquiescence in its continuance. Party not in breach has the options of continuing with the contract and claim damages or repudiate the contract. In section 65, when a person at whose options the contract is voidable resigns it, the other thereto need not perform any promise therein contained in which he is promiser. The party resigning a voidable contract shall, if he has received any benefit thereunder from another party to such contract, restore the benefit so far as may be to the person from whom it was received. For example, in the case of Smith Construction Co. Ltd. versus Fit Kiribati in 1955, when it was held, the refusal to issue an architect's certificate as agreed under a contract amounted to a breach of contract because it prevented the contractor from proceeding with the construction of the building. Since the time is important in the contract, the party not in default has a choice either repudiating the contract or treating it as subsisting. The next case is Tan Hock Chan vs. Kotek Sang. The facts are the correspondent was a building contractor employed by appellant to build certain shop houses and payment was to be made as progress payment. The respondent could not complete work on the final lot because of a claim by the occupier of the land to tenancy rights. When it was held, the failure of the appellant to give effective possessions of the land to the respondent constituted to a breach which entitled the respondent to resign the contract.
Remedies of contract. The subtopic for this topic are the major, specific performance, injunction, quantum merit, and rescission. The purpose of the measures is to compensate the victim for the loss that caused him by the breach of contract, and also not to punish the party in default. There are three categories of damages. First, substantial damages. It is pecuniary or monetary compensation. And the second one is nominal damages. It consists of small token award and the plaintiff suffered no actual loss. And the last one is exemplary or punitive damages. It consists of sum awarded which is far greater than the actual pecuniary loss suffered by the plaintiff. Liquidated damages is the amount of damages is stipulated or fixed by the parties under the contract. It consists of compensation for breach of contract where penalties stipulated in Section 75 and also duty to mitigate loss in Section 74. And this is the example case of the liquidated damages. Second subtopic, specific performance. It consists of jurisdiction is discretionary. The court is not bound to grant new leave because it is lawful. And the discretion of the court is not arbitrary but sound and reasonable. Specific performance available when an order of court requiring a party to perform in turn the very obligations. The purpose is to put the parties in the position to perform their obligation. For the third subtopic is injunction. An order of court to restrain the doing, continuous or repetition of some wrongful conduct which is against the contract. The condition for the grant of an injunction: first, have interest to protect. Second, damages must be shown not to be adequate remedy. Third, danger unless restrained. And the last, breach the contract or continue. There are two types of injunction. First, temporary injunction, to continue until a specified time or until the further order of the court. The purpose is to preserve the status quo of the parties. The second one is perpetual injunction. In Section 51 in bracket 2 Specific Relief Act, only be granted after the full trial and upon the merits of the case. The purpose is to prohibit the defendant permanently and granted. The fourth subtopic, quantum merit. Quantum merit is used for unspecified amount for services rendered and on a quantum merit which is as much as earned. The last subtopic, rescission of contract. The characteristic a party has refused to perform, disable himself from performing, promising may put an end to the contract unless he has revived by words or conduct his acquiescence.